Friends, we are starting now. Today is the 211th Friday group meeting. The topic is prosecution under PMLA and scheduled offences, Part 3 today. The speaker is our beloved senior advocate, Mr. Justice, retired Mr. Nagamuthu, topmost senior advocate of this country in criminal law particularly. Earlier also, sir addressed on arrest and bail in PMLA cases, Part 1 and 2. This is going to be a Part 3. Thank you very much, sir, once again.
Good afternoon, friends. I am very happy to meet you once again, almost on the same subject. During my earlier lectures, I covered two very important topics in the PMLA. In the first lecture, it was about the arrest of accused by the officers of Enforcement Directorate. In my second lecture, I spoke on the provisions relating to bail under the PMLA. I am very hopeful that those two lectures would have been somewhat useful for you in understanding those two topics. Today, as requested by our organizer, Mr. Shesu sir, my lecture is going to be on the topic of trial of PMLA cases and also the cases involving the scheduled offences. I already explained to you that so far as the predicate offences or scheduled offences are concerned, the enforcement directorate authorities have got no jurisdiction or power to investigate at all. Those cases are to be investigated only by either the local police or by any other authority so specified in any special law. I want to repeat, so far as scheduled offences are concerned, the investigation cannot be undertaken by the officials of Enforcement Directorate. Now coming to the offences under the PMLA, I also explained to you that police officers do not have the power to investigate any offence committed under the PMLA. Exclusive power has been given only to the Enforcement Directorate authorities under the Act. So in Vijay Madal Lal, which is a very popular case about which I have already referred to you, there are essentially two criminal activities involved. The first criminal activity makes out the scheduled offence. That criminal activity or that scheduled offence is to be investigated by the police or any other authority who has been empowered so by any special enactment. The second criminal activity is dealing with the proceeds of crime, that is after the commission of the scheduled offence. Any property derived out of the same is dealt with by someone. Regarding this dealing with the scheduled offence, with the proceeds of crime, which we call as second criminal activity, investigation can be done exclusively by the authorities under the Enforcement Directorate. This also I already explained to you. Now we are at the next stage. After completion of the investigation of the scheduled offence by the police, let us take the case of an offence under Prevention of Corruption Act. Investigation is done by the police, and final report under section 173(2) is to be filed before the special court under the Prevention of Corruption Act. That is the first criminal activity. Now, these authorities under the Enforcement Directorate, they do investigation in respect to the second criminal activity relating to which makes out the offence under the PMLA, and they cannot file a final report or charge sheet under section 173(2) because the attempt of the bar before the Honorable Supreme Court to brand these officers or also as police officers failed in Vijay Madan Lal. In Vijay Madan Lal, the Honorable Supreme Court has categorically declared that these officers are not police officers at all, and therefore Chapter 12 of the Code of Criminal Procedure, which speaks of the procedure for investigation of any offence by the police, is not at all applicable to the officers of Enforcement Directorate. It has also been held that the investigation by the Enforcement Directorate officers cannot be equated to an investigation or strictly in terms of investigation as dealt with in Chapter 12 of CRPC. This Honorable Court has held that the term or expression investigation as used in the PMLA is to be understood in the sense of an inquiry. In other words, they are interchangeable. It is in the nature of inquiry. The purpose of the inquiry, as I pointed out to you during my earlier lecture, is only to prevent money laundering and bring back the laundered money to the main stream of the economy of the country. Incidentally, out of the investigation, prosecution used to be launched. So to this extent, and I think that I covered in my earlier lecture. Now, after completion of the investigation by an officer of the ED, what he has to do is not to file a police report, which I already told you. Now, what he has to do? He has to file only a private complaint. He has to file only a private complaint. Now, question is, where such a complaint is to be filed by the officer? Who has got the authority? Can it be filed before a magistrate? Can it be filed before a court of session? Or can it be filed before any other court? Answer is found in section 43 of the PMLA. Under section 43 of the PMLA, a special court is nominated. Please understand, a special court to try the offence under PMLA is not either established or constituted. Please understand this. This makes a lot of difference. A special court under the PMLA is neither established nor constituted. But a court of session which is already in existence is now notified as a special court under the PMLA. So it is essentially a court of session. Already it was a court of session. It is now notified as a special court. So what are the powers of the special court now? Can the special court, being a session court, can take cognizance on the police report? on the complaint. You may at this juncture refer to section 190 of the Code of Criminal Procedure, which gives power to a magistrate to take cognizance of an offence, either on a complaint or on a police report or directly when the offence is committed to the knowledge of the court. So these are the three circumstances in which a magistrate can take cognizance of an offence. But a special court is not a magistrate, correct? Therefore, question may arise as to whether the special court can exercise the power under section 190, which specifically mentions about the power of a magistrate. The second question may be, as a court of session, can it take cognizance? Because section itself says that it is deemed to be a court of session. Section 43 itself says that this court, though nominated as a special court, is deemed to be a session court. Again, it re-emphasizes. Therefore, undoubtedly, it is only a court of session. You all know very well that under section 193 of the Code of Criminal Procedure, the court of session can exercise the power to take cognizance of any offence as a court of original jurisdiction. As a court of original, please underline these things. As a court of original jurisdiction, only in the event the case is committed to it by the magistrate under section 209 of the Code of Criminal Procedure. Therefore, a court of session cannot straightaway entertain a complaint like a magistrate entertaining a complaint under 190 and take cognizance. The court does not have original jurisdiction. The original jurisdiction comes to the hands of the court when only the case is committed by a magistrate under section 209 of the Code of Criminal Procedure. That's the reason why either a police report or a complaint in respect of a case exclusively triable by court of session is not filed before the court of session, it is filed only before a magistrate. The magistrate, after completing all the legal formalities, commits the case under 209, upon which under 193 the session court takes cognizance of the offence, then it proceeds to try the accused. Now, here as I already pointed out, as per section 43, a special court is deemed to be a session court. What are the classes of special courts which are constituted under section 6 of the Code of Criminal Procedure? Please kindly have a look at section 6. These are the classes of criminal courts which are established under the code. Court of session, judicial magistrates of first class, or in the metropolitan area, metropolitan magistrates, judicial magistrates of the second class, and the executive magistrates. These are the classes of criminal courts. A special court constituted under the PMLA does not fall within the ambit of section 6 of the Act at all. Therefore, this special court is not a court governed by or established under the CRPC. This distinction we should note very strongly first. Okay. It is a special court, it is a separate class of court, not falling under any one of the classes as mentioned in section 6. It forms a separate class by itself as a special court. Right. Though it is if it is a special court, it is neither a session court nor a magistrate court. Then what it is? It is a court having original jurisdiction. It is a court having original jurisdiction. Now, in order to avoid any difficulty being faced by the court, section 43 itself clarifies or enshrines that a special court constituted, nominated under this act is deemed to be a court of session. Therefore, for all practical purposes, it is a court of session. In such an event, this court cannot entertain a complaint from a ED officer. How it is filed? Section 43 further proceeds to say that a court of session, the special court may take cognizance of an offence without the case being committed to it on a complaint filed by the Enforcement Directorate. This provision clearly spells out that the special court is competent to take cognizance. When it takes cognizance, the bar under section 193, which is said no court of session shall take cognizance unless the case is committed, now goes. This court can take cognizance now. This power is given under section 43 of the Act itself. The court can take cognizance directly on the complaint filed by the ED authority. Cognizance is now taken. Now, as I already told you, it is only a private complaint upon which cognizance is taken. Then one has to go to the next stage. What is the next stage? You come back to section 190. If cognizance is taken by a magistrate under section 190, then while taking cognizance, he has to follow section 200. He has to follow section 202. That is examination of the complainant, examination of witnesses, and then to dismiss the complaint under 203 or to issue summons under 204. This is the procedure to be followed by a magistrate when it entertains a private complaint or a police report. Here under the PMLA court entertains a private complaint and it has already taken cognizance. After taking cognizance, what is the next procedure to be followed? This has not been dealt with in Vijay Mother law, therefore I am focusing on this area. After taking cognizance, the PMLA court has to follow section 200, 202, 203 or 204. It has to. But if you look at section 200, CRPC, if a complaint is made by a public servant, the examination of the complainant or the examination of witnesses is dispensed with, it is not necessary. Section 200 proviso is applicable to the PMLA court, which says, provided that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses. Please follow. Need not examine the witness, the complainant and the witnesses if a public servant acting or purporting to act in the discharge of his official duties or a court has made the complaint. So, a PMLA, Enforcement Directorate officer, being a public servant, when he files a complaint under the Act before the special court need not examine the complainant under section 200 while taking cognizance. Similarly, the special court need not examine the witnesses cited in the complaint while taking cognizance. These two are dispensed with in section 200 CRPC itself. Same thing applies to the PMLA. Now, a complaint is presented, cognizance is taken, then the court doesn't examine the witnesses or the complainant, then what next? The next stage is section 203. Section 203 mandates that the court shall dismiss the complaint if there are no grounds to proceed further, or if the accused is not known at least. The court will dismiss the complaint under 203. This power under section 203 is very much available for the court under the special court under the PMLA. Court can dismiss the complaint. If the court does not dismiss the complaint under 203, Now the court will have to issue summons under 204 to the accused. This order we call as summoning order. So now on receipt of the summons, the accused appears before the special court. Or if he is already in custody, he is produced before the court. So now he is before the court. Now if it is a magistrate court, as per section 207, in respect of a case instituted on a police report, copies of the FIR, statements of witnesses, other documents, etc. are to be furnished free of cost to him under section 207. It is mandatory. Now here there is no police report. Therefore, copies cannot be issued. This section 207 is not at all applicable. You cannot demand for copies. Then what is the next provision? If you look at section 208, which speaks of the power of a magistrate, copies of the statements of the complainant and the witnesses. If you kindly see 208, see what are the documents for which the accused is entitled for. The statements are recorded under section 200. It is not recorded here. Statements of witnesses recorded under section 202. That is also not followed here, not applicable. No copy could be given. Then statements and confessions, if any, recorded under section 161 or section 164 of the Code of Criminal Procedure. Suppose a PMLA in offender gives a judicial confession under section 164, the accused is entitled for a copy of that. Similarly, if he gives any extrajudicial confession to anybody, the accused is entitled for a copy of those documents also before going for trial. Third one is important. Any documents produced before the magistrate on which the prosecution proposes to rely. So under section 208, the accused is entitled for copies of all the documents upon which the prosecution is going to rely on. What are those documents generally? Number one, the complaint. Number two, search list. Number three, arrest order. Number four, the statements of the accused recorded under section 50. Number 5, statements of witnesses recorded under section 50 of the witnesses, and any other document which is seized or collected during investigation. Therefore, as per section 208 of the code, the accused is entitled for copies of all the documents which is mandatory, it should be supplied. Now, one may have some confusion or question may arise. This section 208 speaks of the power of a magistrate or the duty of a magistrate to furnish. How this is applicable to a special court? Because I already explained that section 43 clearly states that it is not a magistrate court, it is only a court of session. Then how to apply section 208? If 208 is not applied, then the accused is not entitled for a copy of any document. There is no other provision which mandates. It may not be fair on the part of the prosecution to deny those documents because the accused is entitled for notice, entitled to have notice of all those documents so that he can have an effective defense. So our common sense itself says that the accused is entitled for these things. So what is the provision? It is under section 208. The argument is 208 applies only to a magistrate. See section 208. Where in a case instituted otherwise than on a police report, it appears to the magistrate issuing process under section 204 that the offence is triable exclusively by the court of session, the magistrate shall without delay furnish copies. Well, this provision is applicable to a special court. For that, we have got state authority. This has also not been dealt with in Vijay Madan law, but we have to go to AR on Tulles case 1984, which is 2 SCC page 500. Okay? 1984 2 SCC page 500. That was a case under the Prevention of Corruption Act. There is a special court constituted under section 4 of the Prevention of Corruption Act. Of course, the judgment deals with the old act. Let us take the new act. Section 4 of the Prevention of Corruption Act speaks of a special court. Section 3 speaks of the establishment of a special court for cases triable by special judges. Notwithstanding anything contained in the Code of Criminal Procedure or in any other law for a time being in force, the offences specified in subsection 1 shall be tried by the special judges only. Every offence specified in subsection 1 of section 3 shall be tried by the special judge for the area within which it was committed. Then, therefore, when this provision came up for consideration before the Constitution bench, this court has held that the special court constituted under the Prevention of Corruption Act is not a magistrate, but still it is a court of original jurisdiction. As a court of original jurisdiction, this court has got all the powers of a magistrate who has got the original jurisdiction. So this is the judgment law by the Constitution bench which says that though it is not a magistrate court, the special court is a separate class of court having original jurisdiction. It is a court of original jurisdiction. 193, I have already told you, no court of session shall take cognizance of an offence under the except upon the case being committed. As a court of original jurisdiction, this expression as a court of original jurisdiction is used in section 193. Here in this judgment in AR and Place case, the Constitution bench has categorically held that though it is not a magistrate strictly, it is a court of original jurisdiction having all the powers of a magistrate. Therefore, as a court of original jurisdiction, exercising powers which are akin to the powers of a magistrate, this court is bound to follow section 208. Though section 208 speaks of a magistrate, it should be understood that as a court of original jurisdiction, a special court under the Prevention of Corruption Act has got all the powers of a magistrate. It is only under that provision 208 is to be followed. Now coming to the PMLA, this is a court of session, but still it has got all the powers of a court of original jurisdiction. In such a way, this court has got power under section 208, or it has got a duty under section 208 to furnish all the copies of the documents to the accused. So we can demand for copies. Now, in suo motu criminal writ petition number 1/2017, a 3-judge bench of the then Chief Justice, Honorable Justice Bobde, has held that the accused is entitled for copies of documents not only which are proposed to be relied on by the prosecution, but also of all the documents which form part of the record of the case. The accused is entitled for. There is a duty cast upon under section 207 and 208 to furnish copies without being asked by the accused. It should be given. But on appearance, if the accused demands copies of any other document which forms part of the court record, he is entitled for those copies as well. Therefore, it cannot be said that the ED authorities or the court won't give copies of these documents like that. They cannot say. They have got no choice. It is a choice of the accused to demand for copies of every document, irrespective of whether the document is going to be relied on by the prosecution or not. He is entitled for. Correct? So therefore we can demand for copies of these documents. Now copies have been furnished to the accused. Accused has been summoned under 204. Copies have been furnished. What next? The next stage is the trial. Trial of the case. Now, under the PC Act, it is specifically stated that the special court shall follow the procedure of trial of warrant cases. Here in the PMLA Act, it is categorically stated that the court shall follow the procedure of trial of sessions cases. So the procedure to be followed is only the procedure for trial of sessions cases. In that event, you cannot say that he has to follow the procedure of a magistrate. No, he cannot do. He has to follow the procedure for trial of a sessions case. Now let us go. So what is the procedure for trial of a session cases? It is dealt with in chapter 28. Section 225 states that the trial shall be conducted only by a public prosecutor. The ED officer cannot have his own choice of choosing a lawyer to appear in the case on his behalf. He cannot do. Because before a court of session, the only advocate who can do the case for the prosecution is the public prosecutor appointed under section 24 or the special public prosecutor appointed under the said provision. Nobody else can do. If the trial is held before a magistrate in a private complaint case, prosecution can be conducted even by a private counsel. But since here under the PMLA, the procedure is sessions procedure, the prosecution is to be conducted only by a public prosecutor. Now under the Act, in the PMLA, there is a mandate that a special public prosecutor shall be appointed for a special court. So it is the special public prosecutor appointed the Act by the government alone can do the prosecution case before the special court. This is you can find in section 225. Right. Next one. How to begin with? Accused is there, defense advocate is there, prosecutor is there. How to commence the proceedings? As per section 226 of the Code of Criminal Procedure, the first and foremost stage of a trial before a court of session is opening up the case by the public prosecutor. The public prosecutor should state that this is the case and these are all the charges which are likely to be framed against the accused, and these are all the evidences which are there in our hands. With this we want you to try. This is what is opening the case by the prosecutor. You have to tell these things. These are the documents, these are the witnesses, these are the charges which are likely to be framed, and therefore please go ahead. This opening of the case by the prosecutor here in the PMLA is again by the special public prosecutor appointed under the Act. He opens. It is only a simple formality, though it is an important formality, legal formality, it is a simple formality. He will address the court. then after that what happens? On considering the records of the case and after hearing the prosecutor as well as the accused, if the court finds that there are no grounds to proceed further, the court has to discharge the accused under section 226. Right? A question may arise as to whether the accused has to make an application for discharge. Normally, in practice, we used to file an application for discharge. But section 226 does not require any such petition at all. It is the duty of the court to call upon the defense counsel to address the court, the prosecutor to address the court, to peruse the case records and to come to its own conclusion whether there are materials to proceed further, there are grounds to proceed further. If the court finds that there are no grounds to proceed further, it is obligatory, it is necessary, it is mandatory for the court to discharge. Though discharge is not sought for by the accused, it is the duty of the court to discharge the accused when there is nothing against him. Alright. If the court finds yes there are grounds to proceed further, the next stage comes, that is under section 228, the court has to frame charges. At that stage also, the court has to hear both the parties, because now having come to the conclusion that there are material to proceed further, the court has to decide now as to what are the provisions under which charges are to be framed. Whether it is 302, 304, 306, 304A, like that. Here in this case, under section 4, charges are to be framed under the PMLA. Whether it is simple section 4 or it is 120B also, or any other offence section 34 is invoked. So all these things are to be argued, then court has to frame an appropriate charge. Right. Now after that, examination of witnesses, cross-examination, then questioning the accused, all these things I do not want to take much of the time. Now turning back to section 43 of the Act. Now, suppose the ED authority who conducts the investigation find that there are no materials, whether they can close the case. If it is an investigation by the police, they can file a closure report, we call it as negative report. But here, in any other special enactment to my knowledge, there is no such mandate for the investigating authority to file a negative report, that is closure report. But in this Act, there is a specific provision which says that the officer can file a closure report saying that no offence has been made of. Why such closure report is filed is for two purposes. One, if the accused has already been in custody, he has to be released forthwith, he has to be discharged forthwith. Or if he is already on bail, the bail bond is to be discharged. This is the first purpose. The second purpose is the properties would have been attached by the authority under the PMLA. The adjudicating authority would have made the attachment absolute. But final disposal of the attached properties is to be made only by the special court. Therefore, if a closure report is filed, the court will order for discharging or releasing the attached properties. It is for these two purposes in the Act there is a special provision which says that the ED authority can also file a closure report. This also you please kindly keep in your mind. Now, this is in respect of PMLA. Now come to the predicate offence, the first criminal activity. Where to file a charge sheet? That is investigated by the police. Where to file a charge sheet? Whether that charge sheet can be filed before the PMLA court? No, it cannot be. It cannot be. That is to file only before the regular court, right? If once it is filed there, cognizance is to be taken by that court, and after that, section 43, 48, 48, 44. See, read them. A special court may, upon a complaint made by an authority authorized in this behalf under this Act, take cognizance of offence under section 3 without the accused being committed to it for trial. So this court is empowered to take cognizance of an offence under the PMLA. Now, provided that after conclusion of the investigation, if no offence of money laundering is made out, requiring filing of such a complaint, the said authority shall submit a closure report before the special court. This also I already told you. Then third one is important. If the court which has taken cognizance of the schedule offence is other than the special court which has taken cognizance of the complaint of the offence of money laundering, under subclass B, it shall, on an application by the authority authorized to file a complaint under this Act, commit the case relating to the schedule offence to the special court, and the special court shall, on receipt of such case, proceed to deal with it from the stage at which it is committed. So, this is the court of session. It is a special court. It is deemed to be a court of session. So far as PMLA Act offence is concerned, this provision empowers the court to take cognizance without the case being committed. But in respect to the schedule offence, take for example, it is a murder for gain. This court cannot directly take cognizance. Their cognizance is to be taken by the other court, regular court, and it is to be committed to this court. So here section 193 comes into play. As per section 193, cognizance is to be taken by the court on the case being committed to it. Please, I will read the provision once again. If the court which has taken cognizance of the schedule offence is other than the special court which has taken cognizance of the complaint of the offence of money laundering under subclass B, it shall, on an application, please kindly see, on an application by the authority authorized to file a complaint under this Act, commit the case relating to the schedule offence to the special court, and the special court shall, on receipt of such case, proceed to deal with it from the stage at which it is committed. A special court, while trying the schedule offence or the offence of money laundering, shall hold a trial in accordance with the provisions of the Code of Criminal Procedure as it applies to a trial before a court of session. Now, an explanation was added to this provision which says, the jurisdiction of the special court while dealing with the offence under this Act during investigation, inquiry or trial under this Act shall not be dependent upon any orders passed in respect of the schedule offence, and the trial of both the sets of offences by the same court shall not be construed as a joint trial. So what we understand, there are two offences, schedule offence, PMLA offence. On a complaint filed by the ED authority, PMLA offence cognizance will be taken, it is pending before this court. The other case, is pending for some other court, that case should also come to this court by way of committal. When it once comes here, this court will take cognizance of that offence also. But having taken cognizance, now while proceeding to trial, there cannot be a joint trial, there cannot be single trial. Please understand this. Again, this court should have two trials. One trial in respect of the predicate offence, the other trial in respect of the PMLA offence, section 4. There are to be two trials. The trial in both the cases used to be conducted by the public prosecutor. Now, among these two cases, when the Act has clarified that there shall be no joint trial and there shall be only separate trial, which is to be tried first? Whether it is PMLA or it is the predicate offence or simultaneously. In Vijay Madan Lal, though here and there are some observations, it has not been so clearly held. But I would say, and my opinion or view is also fortified by the observations made in Vijay Madan Lal, that the special court has to first try only the predicate offence. The special court has to keep the PMLA case pending in abeyance. This court cannot try that case first. You know what is the reason? What is PMLA offence? This I in my earlier lecture also I dealt with. What is an offence under the PMLA? A predicate offence should have been committed, that is a schedule offence should have been committed. By committing that offence, some property should have been derived, that is the proceeds of crime. Then the proceeds of crime should have been dealt with in any manner, concealing, parking, spending, like that. This is the second criminal activity that makes out the PMLA Act. So unless it is proved that an offence was committed, number one. Number two, these properties are the proceeds of crime. There is a question of proceeding with the PMLA. Therefore, these two things are to be proved first. Where? Before the same court, by trying the schedule offence first. There is, to my knowledge, there is only one interim order passed by the Honorable Supreme Court very recently on prima facie getting satisfied with this legal proposition. Don't proceed. What is the proposition? Don't proceed with the PMLA case. Stop it. Proceed with the schedule offence first. If in the schedule offence, suppose the accused is discharged, saying that no such offence has been committed, then in the PMLA case he is entitled for discharge. If in the predicate offence, schedule offence case, he is acquitted, then he is automatically entitled for discharge in the PMLA case. Suppose in this case, the accused is convicted for some offence, but no offence of money, no schedule offence is committed, or if the court gives a finding that there was no property derived out of that crime, there also automatically the accused is entitled for discharge in the PMLA case. Therefore, the court has to wait for a logical conclusion in respect of the schedule offence. The trial should be over. Only thereafter they can commence the trial in the other case. See, you take the case of case and counter. In some areas we call it as case and cross case. Arising out of the same occurrence, there are two cases. One is opposed to the other case. Now in Nathilal's case, this Honorable Court has laid down the procedure to be followed. this court has said that both the cases should be tried by the same judge, like a PMLA judge trying both the cases. But trial shall be conducted in both the cases simultaneously. But here in the PMLA, I am of the strong view that there cannot be any such simultaneous trial. Third one, the evidence recorded in one case shall not be used as evidence in the other case. Nadilal says. Why? Section 273 of the Code mandates that the evidence shall be recorded in the very presence of the accused. Any evidence recorded elsewhere in the absence of the accused is no evidence, and the same cannot be used against him. Therefore, in Nadilal, in the matter of case and counter or case and cross case, this Honorable Court has laid down as a procedure that don't make use of the evidence recorded in one case in the other case. It cannot be done. Here, record evidence first in the schedule offence. Don't record any evidence. I would say don't even frame charges in the case. Why? You may have to discharge the accused in the event the main case ends up in favor of the accused. Therefore, stop. Don't even frame the charge. We have to stop framing of charge. Then in Natilal, what is the next stage? After conducting simultaneous trial, deliver judgment on the same day in both the cases. But don't apply that principle here. Here, as I already said, that complete the first trial. Don't begin the second trial at all. Don't even frame charges. Don't apply Nadilal principle here. This is separate. So, two trials are to be conducted, one after the other. After the first is over, you got to begin the second one. Natilal is reported 1990, supplement SEC page 145. Natilal case. So therefore, this is the procedure to be followed. Now, practically what is happening today? What is happening? We see in the media and both print and electronic media that trial is going on, though the predicate offence is still under investigation. Still that case, trial has not commenced. Trial is going on in this case, PMLA. Even courts, I am saying about the courts have made observation. What is the stage of the case? PMLA, 2 witnesses have been examined, 3 witnesses have been examined. All right, let the trial go on. Let the accused be in prison. Because as I already pointed out to you, section 42 twin conditions are to be satisfied. If twin conditions are not satisfied, accused will be in prison, you go ahead with the trial. I tell you, today in this country, in many places, in many courts, with great respect, this wrong procedure is being followed and PMLA cases are tried far ahead when the investigation itself is still pending in the predicate offence. Tomorrow, suppose I say, in the predicate offence, you are rushing up, you are very hasty in completing the trial, and ultimately you find him guilty also. You can't give any finding. I tell you, if the trial goes on for very fast, without any conclusion, in the predicate offence, could the PMLA court say the predicate offence was committed? Who is he to say that? What is his jurisdiction? Without having conducted the trial, in the PMLA case, can he give a finding? Yes, there was a predicate offence committed. Can he give a finding? Yes, these are all the proceeds of that crime. Can he give a finding? No. Then, if these two findings cannot be given by the PMLA court, how can the PMLA court punish the accused at all? For want of jurisdiction, in that case, in the PMLA case, if the court cannot go into these two questions and give a finding, how can it decide the third question against the accused? So what will happen? Ultimately, the case should end in acquittal only. That is the only possibility. That is the only possibility. When a lawyer argues before the PMLA court, look, you don't have the power to go into the question whether the predicate offence, murder for gain, was committed or not. You cannot decide that. That is to be decided by in the other case. That case, investigation still pending. One. Second, look, you cannot decide whether these properties are gained by committing that crime. That also you cannot decide. If these two things cannot be decided, there is no proceeds of crime available, and therefore where is the question of convicting the accused for having dealt with the same? Not possible. Therefore, practically speaking, trying this PMLA case first is, in my humble view, is an illegality or improper or procedure being followed. Number one. Number two, I will give you another situation also. Suppose you go ahead with the trial first of the PMLA case and wrongly you convict the accused. I don't say that it is a rightly or wrongly. I say it is only wrongly. Rightly it can't be, because you cannot decide these two issues. Therefore, if at all an accused is convicted by the PMLA court, it is only wrongly. He is in prison now. He is undergoing, rightly or wrongly he has been convicted, he is undergoing prison. Now you take up the first case. Investigation is completed. You take up that case. Police officer says that this offence was not at all committed. He files a closure report. That is accepted. He says that there was no proceeds of crime at all in this. That is accepted. Then this case will be closed. The closure report will be accepted. Or even assuming the trial goes on, the accused may be acquitted here. After he is acquitted, here in the predicate offence, holding that no offence, predicate offence was committed, what will happen to the conviction already recorded in the PMLA? In the PMLA, please tell me. In Vijay Madan Lal, this Honorable Court has very categorically held that in the event the accused in the predicate offence or schedule offence is either discharged or the case is quashed or the accused is acquitted, then you cannot proceed with the PMLA case at all. You have to drop it. Which means what? You have to discharge the accused. You have already taken cognizance, you have to discharge the accused. Correct? Now, if you have already convicted him, how can you drop the proceedings now? How can you do that? You are already convicted. You have become functus officio. You cannot do anything more. Therefore, it strikes our common sense, our legal sense, and as rightly, as rightly held in Vijay Madan Lal, that the trial of the predicate offence is to be conducted first. One minute, please. Not this. PMLA. I will show you why it cannot proceed on a notional basis. So therefore, my dear friends, that the procedure being followed, please be careful. Many of you may be doing a PMLA case. Try this. Tell the correct position of law that you cannot try this case. Stop it. As I already told you, to my knowledge, I advise some people to take this defense, and the matters are being argued in various high courts by filing petition 482, asking the court to keep it in abeyance, don't proceed with the trial. The matters are being argued, and before this honorable court, very recently, at least 2 weeks before accepting this plea, prima facie having been satisfied, this honorable court has stayed the proceedings of the PMLA court, that is taking the trial of the PMLA offence. Right? Okay. Now come back. This is a procedure to be followed. Now let me slightly move on to the appreciation of evidence. Just for 5 minutes, I will close this. Appreciation of evidence. Now, there is a presumption under section 24 of the Act that when there is a prosecution, there shall be a presumption that the proper proceeds of crime are involved in money laundering. That is the only limited presumption. This extensively I have dealt with in my earlier lecture, referring to section 24. Friends, don't have that impression that presumption is not to presume the guilt of the accused. It is not such presumption at all. The presumption is only limited. First thing, there is a predicate offence committed, proved. Second thing, these are the properties, proceeds of crime derived out of that, proved. If these two things are proved before the other court in the first case, then comes the presumption under section 24, that too after a complaint is made. What is the presumption? Presumption is that this proceeds of crime is involved in money laundering. There is no presumption that this accused is involved in money laundering. Please kindly understand this. It is not person specific. It is only property specific. This property is involved in money laundering. Who used it? Who did that money laundering? On that question, there is no presumption at all in section 24. That is to be proved beyond reasonable doubt against the accused. Allegation is that this accused involved this property in money laundering. The involvement of this property in money laundering is presumed, but the involvement was made by this accused is not presumed at all. That is what this is a limited presumption of section 24. I have dealt with it very elaborately last time, therefore I do not want to go into that again. Now, what is the evidentiary value of the statements recorded under section 50? There are two kinds of statements. Statement number 1, statement recorded from the accused. If that statement amounts to an offence, amounts to a confession, it can certainly be used as evidence against the maker under section 24 and against the co-accused under section 30 of the Evidence Act. So this is the limited purpose of the confession made by an accused under section 50 to the ED officer. We know very well that it is too well settled that an extrajudicial confession is a very weak piece of evidence. Unless it inspires the confidence of the court cannot act upon the same, and the said confession cannot be the sole basis for conviction. The court has to look for corroboration from other independent sources. One confession cannot corroborate the other confession. That is, A gives a confession under section 50. The other accused B also gives a confession. The confession of A cannot be taken to corroborate the confession of B or the vice versa. The confession of the accused should be corroborated by independent sources. So this is the purpose for which the 50 statement of an accused could be used. 1. 2. Suppose the statement has been recorded from the witness. What is the evidentiary value of that statement recorded in section 50? Okay, it will be used during trial. Now friends, if it is a statement recorded by the police under section 161 CRPC, it is inadmissible in view of the bar contained in section 162. Regarding that, we know very well. Now, so far as section 50 statement is concerned, there is no such bar at all. There is no such bar at all to admit the same in evidence. It is admissible. Suppose it is admitted. Now comes the evidentiary value. Question of evidentiary value. What is the value? Can the statement be the foundation for conviction? Absolutely not. Absolutely not. Because as per section 157 of the Evidence Act, this being a formal statement can be used only for corroborating the maker of the statement when he is examined in court. Right? And the statement is marked in evidence like 164 statement. What for is it marked? It is only to corroborate the maker of the statement or to contradict him under section 145 of the Evidence Act. Now, suppose the maker of the statement, the witness, turns hostile. He says that, no, I do not know anything about the occurrence. But he says, yes, I gave the statement. Can this statement be treated as evidence and the accused be convicted? No. It cannot be treated as substantive evidence at all because there is no provision in the PMLA Act making this statement as substantive evidence. There is no provision. Therefore, we have to fall back on section 157, which prescribes the limited use of the statement. That is, it can be used only for corroboration by the prosecution, contradiction by the adverse party. Only for that purpose. The witness, suppose he turns hostile, the statement can be used only for a contradiction because his evidence in court is substantive, that is oral evidence given on oath in court is substantive. Please kindly keep this always in mind. What is said in court on oath during trial is substantive evidence, substantive oral evidence. It may be shaky, there may be doubt. To strengthen that, we need corroboration. That corroboration may be drawn from this statement of the very same witness recorded in section 150, under section 50. Statement of one witness cannot go to corroborate the other witness. The statement recorded under section 50 of a witness can be used to corroborate him alone, the maker alone, not anybody else. But if you go to NDPS Act, the Act itself makes the statement a substantive evidence. Section 53A, I believe. It says that the statement itself is substantive evidence. But here, in the PMLA Act, fortunately, there is no such provision. Therefore, 157 is the only provision under which section 50 statement can be used for corroboration, or section 145 of the Evidence Act, which can be used to contradict the maker. Right? This is statement of section 50. Then other documents, in respect of other documents, in respect of examination of witnesses, same procedure that we follow in the matter of, and the same weightage and the same kind of appreciation as we do in any other session case. I think that to some extent, within the limited time given to me by my great friend Mr. Rao, I think that I have said something which will be useful for you, and beyond that, for want of time, because we have started seeing the time also, so the time has come for me to conclude my speech. I think that if there is sir will also.
Please, sir, please.
So in conclusion, I will say we have made a very deep analysis of various provisions of the PMLA in my 3 lectures which I made consecutively. Regarding the first comes investigation, During investigation, arrest comes. During investigation, entering upon a place, search, seizure, all the powers are there. Akin to the powers of the police, but they are not police officers. Investigation is equivalent to an inquiry. It is not stricto sensu an investigation as done by the police. We already covered. Then so far as bail is concerned, remand, bail, all those things we already covered. Now today, to some extent, I have told you about the jurisdiction power of the PMLA court while trying the schedule offence as well as the PMLA, and how the evidence is recorded, how it is appreciated, and how it is concluded, and which trial should be conducted first. That is very, very important. With this, I think that I can conclude. Thank you so much, sir, for having given me the space of hearing. Thank you so much. Thank you.
One. Thank you very much, sir. The entire PMLA you covered like anything. Part 1, 2, 3. We are highly grateful to you. I request all of you give me at least 1 minute claps for sir. Stand up and give. Stand up and give. Now I request Rahul Agarwal will give a vote of thanks.
Sir, one question.
One.
Second question.
Yeah, I feel highly delighted to give vote of thanks for today's lecture. Thanks, Shishu sir, for giving me this opportunity. Sir, as always, your today's lecture enshrined all of us with provisions relating to PLMA offences, which includes arrest, bail, and trial. Sir, in your very first lecture, you very beautifully explained provisions related to arrest of persons in the PMLA case. The second lecture, sir, you dealt with the provision linked to bail, and today, sir, you very beautifully explained all provision relating to trial of the accused in the PMLA case or the schedule offences. Thanks, sir.
Yeah, please, question answer.
Schedule offense